Trade secret law. Let's look at a few of the aspects of trade secret law and see how they apply. Trade secret is a form of intellectual property that derives independent economic value, which is actual or potential, from not being generally known. And number two is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. That is, it has to be something that has some economic value by being kept a secret. And number two, the owner of the intellectual property has to engage in some reasonable efforts to keep it a secret. Trade secrets can fall into two categories. One is commercial proprietary information. The classic form of this trade secret, which is commercial information, is customer list. Another is pricing information. Many companies do consumer surveys to determine what's the optimum price to sell their product at. If they sell it too high, consumers won't buy. If they sell it too low, they won't make a profit. So they try to determine what's the optimum price point. And so they do consumer surveys. Also, marketing techniques need to be the subject of trade secret protection. The second form of trade secret protection is technical data, such as research and development data, test runs, production techniques, a formula or a process. For example, in the late 1880s, a chemist and pharmacist in Atlanta invented a formula for a new beverage. It had traces of a controlled substance. Around the early 1890s, they sold the formula to Asa Candler, who then cleaned it up. He then gave it to market it as Coca-Cola. The first two syllables are suggestive of one of the early substances. It doesn't have any of that in it today. And so he decided to keep it a secret. He could have obtained a patent, and after the patent expired, anyone could have made the formula. However, he decided to keep it a secret. And to this day, the process for making Coca-Cola is kept a secret. The contents are well known. You can read it on the side of any container. But the process is a secret. And so the motion picture industry decided that they were going to rely on trade secret law to see if they could stop the distribution of decis. So they went to court. They filed their lawsuit in Superior Court of the state of California up there in Santa Clara Valley. It's up there if you're in Los Angeles. It's out there if you're in Cambridge. It's in Silicon Valley. And they decided in December to file a lawsuit against all of those who were distributing decis, and they alleged that these people were misappropriating trade secrets that were owned by the motion picture industry. The lawsuit was styled DVD Copy Control Association versus Bunner. That was a trade association, DVD Copy Control Association. I think that, well, they sued a lot of the people who are distributing decis. I think that the reason that they identified Bunner is that they identified all of those who were distributing it in alphabetical order, and Bunner just happened to have been the first on the alphabetical list. Well, they decided that they were going to go into court to seek a temporary restraining order and preliminary injunction. Sir?
So what they alleged was being stolen was not the materials that were protected by the CSS, but the CSS itself was being appropriated somehow? That was the allegation? Yeah, the allegation that there was a distribution of decis which could have unscrambled CSS. What was the, but why did that, so they were claiming a trade secret, theft of a trade secret? Correct. Okay. Right. Sorry, question.
If it's so easy to unscramble, why is that considered like a reasonable effort to keep it a secret?
Pardon me?
If it's so easy to unscramble the code just by sending out one program, why is that considered a reasonable effort to keep what they had a secret?
Yeah, that's what the court asked. So you're getting to the punchline or the final decision. So, okay. Actually, after they filed their lawsuit, this generated some sort of digital civil disobedience. They went into court on December 27, 1999, in order to obtain a preliminary injunction and temporary restraining order. In fact, this outraged a lot of hackers Some of them appeared on the steps of the Santa Clara County Courthouse, and they tried to spread DCIS as widely as possible. Some people appeared in the courthouse to pass out diskettes and written flyers that supposedly contained DCIS. They felt just like you did. They made and distributed T-shirts with parts of the code printed on the back. There were even contests encouraging people to submit ideas on how to disseminate DCIS as widely as possible. There was a question there, ma'am.
So the trade secrets never expire. Essentially, had anyone ever, was there like a precedent for someone suing for a trade secret violation, or is it because it was a technology thing that had never happened before? Like,
well, I think what you're getting to is the fact that now they're going into court to try to stop distribution of a trade secret which is not there anymore. Okay? But it took 4 decisions at each of the 3 levels of the California judiciary to get to that point. Thank you for getting to the punchline quickly, but bear with me, please. The trial court initially granted a temporary restraining order and an injunction against the distribution of DCIS. Well, it went up to the California Court of Appeal, and they said, well, there's First Amendment issues. We'll get to that. The First Amendment, this is a violation of the First Amendment freedom of speech and also the corresponding section of the California Constitution. Most states have a section in their own Constitution which corresponds to the First Amendment freedom of speech. The case then went up to the California Supreme Court. They said that freedom of speech is no defense to violation of a trade secret, of violation of trade secret laws and trade secret rights. So they sent it back to the Court of Appeal for a decision based on that ruling. That is, the First Amendment, trade secret laws are not unconstitutional based on First Amendment freedom of speech. So by this time, the defendants began to see that the case was going their way. The plaintiffs, the motion picture industry, began to see the case was not going their way. So they tried to dismiss the case without prejudice to refile. The defendants were smelling victory, so they said, no, we want a decision, and it was a smart, strategic decision. They got to the point that you did pretty quickly. They thought that there's no secret to protect, and on that basis, they should be entitled to a decision on behalf of the defendants. The second time the Court of Appeals decided the case, they decided in favor of the defendant. The Court of Appeals stated that a preliminary injunction cannot be used to protect a secret if there's no secret left to protect. Right? That makes sense. The Court of Appeals noted that there is no evidence as to when Bunner first posted DCIS and no evidence to support the inference that the content scrambling system technology was still a secret when he did so. There was a great deal of evidence, in fact, to show that by the time the DVD Copy Control Association sought the injunction prohibiting disclosure of DCIS, DCIS was so widely distributed that the content scrambling system technology may have lost its trade secret status. That is, there was no evidence that Bunner misappropriated it. There's no evidence that Bunner engaged in some industrial espionage, tried to sneak into the offices of the plaintiff and steal their technology. He just got some information that was otherwise publicly available. Now, the court did make a rather interesting statement. The court states that the behavior of the defendants is unethical and probably violates other laws. But that which is in the public domain cannot be removed by action of the states under the guise of trade secret misappropriation. What are the other laws they were referring to? Well, it was the DMCA, the Digital Millennium Copyright Act.